Yeah, well, thanks for joining me. I'd like to welcome Mark Joseph Stern, staff writer at Slate and author of American Justice 2019, The Roberts Court Arrives. Really appreciate your time.
Of
Yeah, I
course.
wanted to ask about the recent piece that you wrote for Slate titled "SCOTUS Just Blew Up the Voting Rights Act's Ban on Racial Gerrymandering." In the piece, you noted that even Chief Justice John Roberts, a longtime opponent of the Voting Rights Act, dissented from the ruling in Merrill v. Milligan. Can you give a bit of a background regarding the court's prior efforts to hobble VRA protections and what implications that decision may have for the future of democracy?
Yeah, so in a 2013 decision called Shelby County v. Holder, the Supreme Court dismantled the Voting Rights Act's heart, really, sort of like the crown jewel of the law, which was its pre-clearance requirement. And this was a rule that states with a history of racist voter suppression had to submit any planned changes to their election laws to the United States Department of Justice for approval before implementing them. And in Shelby County, the Supreme Court essentially said racism is over. Congress couldn't dig up any really good examples of racist voter suppression that's still going on in these states. So we're going to dismantle this provision. And that unleashed a wave of new voter suppression laws over the next few years. Including really draconian new voter ID requirements, thousands of poll closures disproportionately in Black and Hispanic communities, all kinds of restrictions on mail voting that tended to have a disproportionate impact on racial minorities and Native Americans, actually. And some of those laws were challenged under what remained of the Voting Rights Act, which was Section 2, which is a kind of complicated formula to prohibit a voter suppression law that has a disproportionate impact on people of color. It's not quite that simple, but the basic idea is if there's a law that makes it much harder to vote for people of color and really seems to target or directly affect those communities, then it's illegal. And in a recent decision called Brnovich versus DNC in 2021, the Supreme Court really gutted that test as well and made it almost impossible to win a case under that sort of disparate impact provision of the Voting Rights Act. And after that, all that was really left was this ban on racial gerrymandering, which is one of the centerpieces of the law and has stood the test of time, at least until this decision in Merrill, because it's a pretty simple directive. States, when they are redrawing their legislative and congressional maps, do not get to pack all of their Black voters into as few districts as possible and then distribute the few remaining Black voters throughout a bunch of majority white districts so that Black voters have very little political power and end up being sort of packed together and only controlling a very small minority of districts. That's exactly what Alabama did in this latest round of redistricting. Alabama's congressional map is just a quintessential racial gerrymander. The state is almost a third Black, almost a third of the population is Black. But under this map, only 1 of 7 congressional districts even has a majority Black population. So Black residents only control like 1 out of 7 congressional districts, 14%, when they make up almost a third of the population. That is obviously illegal under the Voting Rights Act. And in a unanimous decision, a 3-judge district court said so and issued a 225-page ruling meticulously explaining all of the reasons why this map was illegal. And it's worth noting that 2 of the 3 judges on this court were nominated by Donald Trump. So this was not some kind of radical liberal fantasy. Like, this was a very clear application of the law. Nonetheless, by a 5-4 vote, the Supreme Court stepped in and blocked that decision, allowing Alabama to use this racial gerrymander for the 2022 elections and some indefinite period beyond that. We can talk about that later, and did not explain its reasoning. And so it was left to basically Elena Kagan and Chief Justice Roberts to say this is really not the correct way to deal with voting rights cases. The lower court did everything perfectly. It acted like we always tell courts to act and applied the law very rigorously. And it is not our place to step in here and preserve these illegal maps when the election is so far off that there is plenty of time for Alabama to go back to the drawing board, fix these maps, and hold elections in constitutional and legal districts under the Voting Rights Act.
So yeah, as far as like going forward, are there any recourses, like what other sorts of implications might this have looking into future state gerrymandering? What do you think?
So there are pretty immediate downstream effects because there are two other states, Louisiana and South Carolina, that have large Black populations that were recently redistricted out of power. And in both of those states, there's litigation to force the legislatures to comply with the Voting Rights Act. And there was a real chance that we would see court orders requiring those states to actually follow the law. After this decision in Merrill, it's very unlikely that either the district courts or the Supreme Court will allow judges to order VRA compliant maps. It seems like there's just no chance that we're going to see more Black districts in Louisiana or South Carolina. There are also some states as we speak that aren't finished redrawing their maps. And those states now have a kind of rubber stamp to just go hog wild and gerrymander their Black and brown communities out of any kind of meaningful power. So there's no immediate recourse here. Unfortunately, we're just going to see a bunch of losses in VRA cases. Of course, Congress could try to fix this, to patch this hole. And actually a bill that the House passed protecting voting rights included a provision that would have, in theory, prevented this ruling. But of course, that bill did not pass the Senate due to the filibuster. And so it is not law. And as long as the filibuster remains, it seems very unlikely that Congress can do anything about any of this.
I wanted to switch gears and get your insights into the court's ongoing assault on the Establishment Clause. If you would. You wrote in your book that conservative justices are pummeling Lemon because they're laying the groundwork for a First Amendment revolution that would interpret the Free Exercise Clause to require what Lemon forbids. So just an update, what is the Lemon test? How have recent SCOTUS decisions eroded the Establishment Clause in favor of free exercise?
So unfortunately, I hate it when I'm right, but I was right in that prediction, which I guess I made in 2019. So the Lemon test is the standard that has been used for quite some time by the court to determine when there is a violation of the Establishment Clause. And it asks three questions. The purpose question, which is, does this law have a secular purpose? The effects question, which is, does this law have the effect of either advancing or inhibiting religion? And the entanglement question, which simply says, does this law create excessive state entanglement with religion? This test got a lot of criticism from conservative justices, but I think it actually makes a lot of sense. It was devised by conservative justices back in the days when they did not want to repeal the separation of church and state. And I think it served fairly well to separate out laws that were maybe influenced by religion, motivated by lawmakers' religious desires, but had a fundamentally secular effect and some secular purposes, and laws that were just promoting Christianity and trying to establish Christianity as the state religion. But the court has almost entirely disavowed the Lemon test and instead shifted to a very, I think, aggressive reading of the Free Exercise Clause that essentially gobbles up the Establishment Clause and really kind of just erodes or bulldozes the separation of church and state. So to back up a little, there's two religion clauses in the First Amendment, right? The First Amendment says that Congress can't respect an establishment of religion, and it also can't inhibit or abridge the free exercise of religion. And so for a while, the court said that there was play in the joints between those two clauses, that a state could say, we're not going to say fund these religious scholarships because we don't believe in entangling ourselves with religion. And even if funding that scholarship wouldn't technically violate the Establishment Clause and the separation of church and state, the Supreme Court said that's fine. States have a valid interest in preserving a neutral stance toward religion and in maintaining neutrality toward religion so that no religion is preferred above others, and so that religion itself is not preferred above non-religion. And in recent years, the conservative majority has absolutely nuked that whole concept and replaced it with this idea that basically there is no Establishment Clause. Neil Gorsuch calls it the so-called separation of church and state. And the Free Exercise Clause requires states to favor religion because, and Kavanaugh almost put it exactly this way during recent oral arguments. He said, neutrality toward religion is hostility toward religion. So the new idea on the court that's ascendant is if a state does not actively favor religion and fund religion and promote religion and subsidize the exercise of specific religions, then the state is actually disfavoring and discriminating against those religions, and that violates the Free Exercise Clause. So that sort of turns Lemon on its head, because Lemon says that the watchword in Lemon is neutrality, and now the principle is neutrality is evil, neutrality is discriminatory, and the government actually has an affirmative duty under the Free Exercise Clause to fund and subsidize the exercise of religion.
So would you say that we're essentially like kind of heading down a path toward the furthering of an American theocracy?
Theocracy is a big word. I try not to throw it around too much.
Sure.
What I will say is that we're moving to a place where minority religions and people who do not have a religion, so atheists, agnostics, Jews, Muslims, etc., will be able to look at their government and feel quite rightly that their government is forcing them to subsidize religious exercise that violates their own freedom of conscience. So, for instance, there are lots of things that Catholics believe that Muslims don't believe. Catholics teach and preach things that directly contravene Islamic teachings. And yet, in, say, Maine, where this latest Establishment Clause and Free Exercise Clause case has come from at the Supreme Court, soon Muslims will be obligated through their taxpayer dollars to finance Catholic education and Catholic worship. And that is the exact kind of thing that James Madison said he wrote the Establishment Clause to prohibit. If you go back and read all of his writings around this period, he said the number one evil here is collecting money from person A to subsidize the religious exercise of person B when person A doesn't hold those beliefs. Like, that was considered by Madison to be a core violation of freedom of conscience. And the Supreme Court has just completely disavowed that very concept, that principle, and instead said that, like I said, the government just has to extend a hand to any religion that wants government money and use the public fisc to subsidize these religions. And again, if you are a Jew or an atheist or a Muslim in Maine, very soon you will be legally obligated to be underwriting very conservative Christian religious schools that use this money, your money, to force children to worship and teach them religious beliefs that you don't agree with. And those people are totally out of the equation with the Supreme Court. This Supreme Court never considers religious minorities or non-religious people in these decisions. They're totally written out, and the only people who matter are the very religious ones who are demanding state funding for their own religion.
Does this all basically stem from the Trinity decision?
So yes, and I think it's funny because Trinity Lutheran was actually a 7-2 decision, right? So Justice Kagan and Justice Breyer sided with the majority in this decision, and Justice Sotomayor wrote an incredible dissent, joined by Justice Ginsburg, that was extremely prescient, I think, in pointing out why the court had started down a very dangerous road. Trinity Lutheran involved this program where schools could apply for a tire recycled tire playground resurfacing program. So if you won this competition or this grant or whatever, like your school got a new playground surface made of recycled tires. Not a huge deal either way, like doesn't seem like the makings of a major constitutional showdown. But the state of Missouri has a constitutional provision that bars the subsidization of religious schools and religious exercise. And so the state told Trinity Lutheran when it applied for these playground resurfacing grants, you actually can't do this because we're not legally permitted to fund your school. And by a 7-2 vote, the Supreme Court said that that was a violation of the free exercise clause because it discriminated on the basis of religion and on the basis of religious status. And what Sotomayor pointed out, I think quite brilliantly, is that the recycled tires on the playground are just as much a part of the church's religious mission as the nails used to construct the crucifix. Children at that school are taught very devout Christian beliefs, and the playground is used to further those beliefs, to encourage children to adopt and promote these Christian views. I mean, it sounds a little bit silly because you think of playgrounds, you hear monkey bars, but the playground was really part and parcel with the school's religious mission. And Sotomayor warned that by doing this, the court was really kind of opening the door to forcing other states to begin funding religious education, because there are a lot of states that provide some funding to secular private schools, whether it's through vouchers or through tax credits, but say we don't want to fund religious schools because we don't believe in funding religion. And Sotomayor was exactly correct. This is exactly what's happened.
To switch gears again, I wanted to ask about Roe v. Wade. Kennedy's departure from the court has kind of allowed an onslaught of new challenges to abortion rights. Do you think it's likely that the Roberts Court will eventually overturn Roe, or will the conservative justices be satisfied with simply hacking away at it like they've been?
I think that the court will overturn Roe, and I think it will do it this June.
All right.
Well, I mean, if you listen to oral arguments, it's pretty easy to count to 5. This is something that Justice William Brennan used to tell all of his clerks. The only rule that matters around here is the rule of 5. Like, if you've got 5 votes, you can do anything. And that's the situation with Roe. It's very clear that Gorsuch, Thomas, and Alito are raring to overturn Roe, and they have been for some time. Brett Kavanaugh all but declared from the bench that he wanted to overturn Roe during oral arguments. He claimed that the Constitution is neutral about abortion, so the court has to be neutral too. And Amy Coney Barrett asked these, I think, kind of offensive questions, saying, why do we even need abortion rights anymore now that there are safe haven laws that allow women to place their newborns at fire stations and run away and disclaim all parentage over them, because, you know, women can still have it all. They just dump their babies at a fire station and move on. Don't worry about those 9 months of unwanted pregnancy. Seems to me pretty clear that those 5 are going to just do this all at once, because if they took the chip away tactic and they tried to just erode Roe and shrink it and continue to cut back on its protections, they would just draw so much heat and so much backlash. When if they do it all at once, there will be a huge surge of backlash, and then I think they hope it'll die down. So from a political perspective, I'm convinced that 5 justices believe it's smarter to just do it now and brace for the backlash, and then hope that it passes and the abortion issue will leave the Supreme Court forever.
Well, can't believe Susan Collins was wrong about that one. Kavanaugh.
Shocking.
So yeah, with Breyer stepping down, Biden gets to make good on his campaign promise to place a Black woman on the Supreme Court. It appears to be down to Ketanji Brown Jackson and Leondra Kruger, although Senator Clyburn has been pushing for the anti-labor J. Michelle Childs. Do you have any sort of idea where Biden's leaning at this point, or do you have a guess as to where he's going to go?
I wish I could tell you I have some special inside knowledge, but I don't. The people who do have inside knowledge are not returning my emails. It's very sad. My understanding from the reporting that is out there is that the White House is leaning towards Ketanji Brown Jackson, KBJ. She seems like the smart pick. She just got confirmed to the DC circuit last year with 3 Republican votes. Seems like it wouldn't be too hard to get Collins and Murkowski at least on board, and then you have a decent margin. You don't have to rely on Kamala Harris. She's really smart. She's incredibly accomplished. She's very eloquent. Her testimony for both of her nomination hearings has been just a home run. And I think that, like, if you want to please the progressive faction of your party without alienating the moderate or centrist faction, this is the way you do it. Leandra Kruger, she is more of a mystery. She doesn't have as much of a developed record. She seems to be more of a kind of cautious and canny moderate in line with Elena Kagan. And J. Michelle Childs, I don't really know what to say about her. I'm not convinced she's seriously in the running. I think that Jim Clyburn has just forced Biden to consider her, at least superficially, because they are apparently friends and it's some good old fashioned patronage. But the fight, I think, is dying down. And I think that KBJ will emerge victorious. And I do believe that if she's nominated, that she will eventually get confirmed to Breyer's seat.
Are you aware of any major cases coming down the line for the Supreme Court this year? Do you have any expectations as to rulings that might have some kind of large-scale implications?
Well, you know, one of the big ones that we haven't talked about is the EPA case, where the Supreme Court is going to decide whether the EPA has the power to regulate greenhouse gas emissions from power plants. And what's really weird about that case is that the Biden administration has not actually done that. There is not a plan or a policy or a regulation issued by the Biden administration or in effect that would limit these emissions. This case has been like roiling the courts for years now. And at this point, it's just a kind of hypothetical. And as you may know, the Supreme Court is not supposed to issue advisory opinions. It's only supposed to decide cases or controversies under Article 3 of the Constitution. This does not seem like a real controversy. This is basically a bunch of coal companies saying, we don't ever want Biden to issue a regulation that could hurt us, so we're going to preemptively try to stop him from doing it in the first place. That is, again, not normal, but I think there's a real chance the Supreme Court will bite. I mean, the court did take up the case. And, you know, this is a court that's very aggressive about dismantling the administrative state, by which I just mean all of the agencies, the EPA, the Department of Labor, Department of Homeland Security, we could go down the list endlessly, Department of Transportation, EEOC, agencies that protect against discrimination, agencies that implement the law that Congress passes. The Supreme Court wants to destroy that system of government, a system that we've had for more than a century now, where Congress passes really broad laws, and these federal agencies tasked with implementing those laws hires a bunch of experts and very smart people, many of whom are actually confirmed by the Senate, and they figure out how to implement them. And if the people don't like it, then they can just vote the president out of office. The conservative legal movement has decided that it doesn't like this system, and that what it would rather do is allow unelected, life-tenured federal judges decide the real meaning of these laws and prevent these democratically accountable agencies from doing anything that a judge doesn't approve of. And so this will be a great way for the Supreme Court to kind of strangle Biden's agenda in the cradle, so to speak, and prevent him from issuing any kind of ambitious regulations on climate change or anything else by saying, you know, you don't get to do anything unless Congress explicitly and expressly authorizes it. And because this language is broad and not specific enough for us, we're not going to let you do it. And that's exactly what happened in the OSHA case about Biden's vaccinator test mandate, which we can get into. But all of these cases point in the same direction, which is just kind of hobbling the work of the federal government, bringing the wheels of governance to a stop.
Finally, the moment may have passed for this, but if Democrats do somehow retain control of the Senate, do you think it would be a good idea to move to pack the court, at least to temporarily stave off some of these more damaging precedents being set?
Well, I don't like to call it court packing. I call it court expansion, and I am for it because There's really no other way to stop this coming conservative legal revolution. It's going to be a bloodbath, and it's going to be a partisan bloodbath that really prevents Democrats from winning elections. Look at this VRA case, which with one totally unreasoned order, the Supreme Court basically subtracted 3 seats from House Democrats, even though the VRA required those seats to exist. I think that adding 4 seats is the only way to rebalance the judiciary and to restore some of its legitimacy after Republicans really kind of destroyed that legitimacy with endless hardball. It doesn't make sense for Democrats to respond feebly or meekly to that kind of hardball. And the reality is that the Supreme Court has become our nation's most powerful policymaking institution. It's more powerful than Congress. It's more powerful than the president. It's more powerful than it has ever been in the past. The Supreme Court is probably the single most powerful government body in the entire world. No other country gives its Supreme Court as much power as we do. Maybe India, but even then, not really. So there's no real structural reform that can work unless you expand the Supreme Court first, because every other structural reform that Democrats attempt will be kneecapped or struck down entirely by SCOTUS. So that's why I am in favor of expanding the court.
All right. Well, Mark Joseph Stern, thank you so much for your time. People can follow your work at slate.com, on Twitter at MJS_DC. Anywhere else you'd like to point folks?
That's it. Those are the good ones.
All right. Well, yeah, really appreciate your time, Mark. Thanks a bunch and take care.
Thanks so much for having me on.
Yeah, you got it.